Thanks, Mr. Chairman. Mr. Pearce, Mr. Griffin, welcome. Good to see you. Mr. Pearce, you said it was the duty of the NLRB to enforce fundamental labor law. Would you agree Section 14B of the Taft-Hartley Act is a part of that fundamental labor law?
Yes, it would be.
And that gives states the right to pass a so-called right-to-work law, which 25 states, I believe, have done, right?
That's right.
Tennessee is one of those states. The Tennessee law says two things. One is you don't have to join a union in order to hold a job. Does that sound like a law authorized by the NLRA?
I believe so, yes. Sure.
And it also says you don't have to pay dues or fees to the union in order to have a job. Does that sound like a right-to-work law authorized by the National Labor Relations Board?
It sounds like a right-to-work law that by statute a state is permitted to have, certainly.
Thank you. Thank you. There is a section of the National Labor Relations Act 8B1A, which the Supreme Court said in 1967 requires a union to serve the interests of all of the members of the bargaining unit, all the employees of the place, whether or not they belong to the union. And the NLRB in 1976 said a union can't lawfully refuse to process a grievance of an employee in the union because he's not a member. In a non-right-to-work state, you can be fired if you try to assert those rights. But what I'm trying to understand is why the board, in April of this year, requested legal briefs in an appeal of a case from Florida that asks these questions, in effect, whether unions in a right-to-work state like Tennessee can force employees who don't belong to the union to pay fees or other dues-like charges. And the legal briefs are to be about whether you can charge those non-union members fees, how much you can be allowed to charge, and what actions a union could take to make sure it gets paid. Why would you ask those questions when the law has been settled for 40 years? That a state may pass a law like the ones I read to you in Tennessee that says that you can't do that.
Well, the case that is before us is one that I couldn't comment specifically on because it is pending.
I'm not asking you to do that,
I understand.
But if the laws that Tennessee has, for example, that you don't have to join a union, and you don't have to pay fees, and the Supreme Court and the NLRB have said that the union has to serve everybody who works at the plant, then why do you ask the question, how much of a fee could they charge?
Well, the issue presented in the case is whether a union can charge a fee for processing grievances of non-members.
That's exactly right, and that's what I read to you. And the Supreme Court in 1967 and the NLRB in 1976 says that a union cannot lawfully refuse to process a grievance of an employee in the union because he's a non-member, period. That's the law.
I agree.
Then why would you ask how much of a fee could the union charge?
The board is soliciting briefs on the question of whether or not a fee can be charged for the processing of a grievance.
But the board has already held that a fee cannot be charged, and the Supreme Court has held the same thing. So why would you change the law?
Well, I respectfully disagree. I think
your opinion said in 1976, a union cannot lawfully refuse to process a grievance of an employee in the union because he's a non-member, unquote.
That's right.
Then why would you ask for a brief on that question and how much the fee could be and what the union could do if the employee doesn't pay it?
The question that is asked for briefing is whether or not it's not a question of whether or not a union can refuse to process a grievance of a non-member, because I think that's a matter well settled, as you've pointed out. The question is whether or not it would be lawful or permissible for a union to charge a fee for the processing of a grievance because of the administrative costs involved in processing a grievance, particularly where non-members are not obligated to pay dues.
It seems to me, Mr. Chairman, and my time's up, that's undermining the right to work law, and there's talk often about middle class. I cannot think of anything more damaging to middle income Tennesseans than anything that would undermine the right to work law. I've seen over the last 30 years how it has attracted the auto industry to our state, created competitive industry, good jobs, helped families. And the reason they came was because we had a different labor environment, because we had the right under the settled law to create a right to work law. And I'm very concerned that just these requests for briefs on law that has been settled for 40 years suggest to me the board is thinking about undermining a state like Tennessee's ability to have a right to work law.